Good afternoon, everyone, and good morning to those of you on the West Coast. This is Joshua Lee, and on behalf of PCI, I'd like to welcome you all to today's session of GovCon 101, covering the Freedom of Information Act, or known as FOIA. We are joined by our expert instructor, Andrew Guy. Before we begin, I do have a few housekeeping announcements and reminders. Those of you new to our GovCon 101, we won't be giving out passwords for those of you seeking credit. Instead, we will have a few polling questions at the end of the slides. Make sure that you are tuned in, listening closely, and participating in those polls at the end if you are seeking credit for today's session. In addition to that, we will not take questions until the end, but we do welcome questions throughout the session, so make sure you guys send in any questions you might have through the questions tab. The questions tab is located at the top right of your GoToWebinar window. If you have any questions about the GoToWebinar application or credit or any of those things, feel free to send a message through. I'll be more than happy to help you out with that. With that, I thank you all so much for joining today. I will hand it over to Andrew.
Excellent. Thank you so much. And good afternoon, everyone. Welcome to Government Contracts 101, Freedom of Information Act. My name is Andrew Guy. I'm an associate in the Government Contracts Practice Group at Covington and Burling. I'll note at the outset that this presentation is intended to provide general information about FOIA. It's not intended to be legal advice, should not be understood as legal advice. Any views expressed in today's presentation are my own and do not necessarily represent positions of Covington or any client. Government contractors may encounter FOIA in a variety of different contexts. In one instance, a contractor's documents may be the subject of a FOIA request, perhaps from a reporter trying to learn more about a government program, or a competitor trying to learn more about the contractor's business. In another instance, a contractor may be the party submitting the FOIA request, perhaps in an attempt to learn more about an agency's award decision, or in an attempt to learn more about the factual circumstances surrounding a potential contractual dispute. This course is designed to provide some background on FOIA and how FOIA may interact with the work of government contractors. Here's a brief agenda for our conversation today. We'll start by providing an overview of the history and structure of FOIA laws, both state and federal. We'll then turn to a discussion of how government contractors may find themselves needing to file a FOIA request or needing to respond to a FOIA request. Following that, we'll discuss the types of records that can potentially be disclosed under FOIA. Then we'll detail the FOIA process from the submission of a request to its ultimate resolution, and we'll then conclude for questions as well as the polling questions that were mentioned previously. So let's begin with a brief overview of FOIA. The next few slides will provide some background on the federal FOIA statute, and we'll conclude by giving some consideration to state FOIA laws. As the quotes on this slide show, FOIA is generally understood as a tool for the public to gain insight into government decision-making. Generally speaking, FOIA allows individuals to access government records they might not otherwise be able to access. Notably, any person can submit a FOIA request. The legal definition of person is quite broad, and it includes individuals, partnerships, corporations, and associations. FOIA has been in existence for several decades and has been a frequent subject of focus for Congress. Starting in 1946, Congress included rules for the publication of records in the Administrative Procedure Act, otherwise known as the APA. As many of you may be aware, the APA still exists today and provides a set of rules for federal agency decision-making. Originally, the APA included a section which gave agencies broad discretion to publish records as they chose. However, by the mid-1960s, Congress decided to take a different approach than that found in the original APA. This was done for at least two reasons. First, many legislators feared that too few agency documents were being disclosed. In the words of a 1965 Senate report, the APA had come to be looked upon as more of a withholding statute than a disclosure statute. Second, the APA had led to, at least perceived as, inconsistent and unpredictable rules between agencies. Thus, a new FOIA statute was created in 1966, and it was intended to provide greater disclosure of documents in a more uniform manner. That statute, which still exists today, is 5 U.S.C. Section 552. The FOIA statute has been amended several times in the decades between 1966 and today. I'll quickly highlight two of those amendments. First, there are the Electronic Freedom of Information Act amendments of 1996. In conjunction with the dawn of the Internet age, FOIA was reformed to address the notion of records that are stored electronically. Two changes still in effect today are particularly worth noting. First, agencies must now produce electronically stored records when responding to a FOIA request. And second, agencies must produce and publish certain documents in an electronic format. Second, and in addition to the Electronic Freedom of Information Act amendments, there's the FOIA Improvement Act of 2016. This is one of the more recent significant amendments to FOIA, and this act made several revisions throughout the FOIA statute, particularly in regards to procedural requirements. The one thing I'll note here is that it includes a requirement that the agency consider producing redacted documents rather than no documents at all. Another highlight is that the amendment requires the Office of Management and Budget, or OMB, to create a single online portal for filing FOIA requests. That portal is something we'll discuss in more detail later in the presentation. Long story short, when reviewing FOIA opinions from before 2016, one may want to confirm whether the 2016 amendments changed the state of the law. There have, in addition to these two amendments, been numerous other amendments to FOIA. For example, the Freedom of Information Reform Act of 1986, the Intelligence Authorization Act for fiscal year 2003. The general takeaway is that FOIA is a focus of constant attention and reform. As noted on the previous slide, the core FOIA statute is 5 U.S.C. Section 552. That statute lays out three core obligations related to the disclosure of documents, obligations which you can see in the three black boxes on the slide here. First, each agency must publish certain information in the Federal Register, and that information is available online. This information includes the agency's rules of procedure and the agency's statements of general policy. You can find a complete list of what needs to be published in the Federal Register at 5 U.S.C. 552A1. Second, this is in the second box you can see in the right corner, each agency must publish certain records for public inspection in an electronic format. This typically means on the agency website. These records include agency opinions that are made when adjudicating disputes and administrative staff manuals. You can find a complete list of these documents at 5 U.S.C. 552A2. Notably, these first two types of disclosures, the first two boxes on the screen, do not require anyone to submit a FOIA request. Rather, the agency must publish these documents sua sponte, on their own. For that reason, these two requirements are known as proactive disclosures. Third, and finally, in addition to these two categories of proactive disclosures, the agency is obligated to produce additional records requested by the public. This is the requirement that typically comes to mind when someone is thinking about FOIA, and it's the requirement we'll be focusing on in this presentation. So that ends our initial overview of the federal FOIA statute, but I did want to provide a few thoughts on state and local FOIA statutes. Although states and localities are not subject to FOIA, many of these jurisdictions have passed their own disclosure rules that operate similar to federal FOIA. A few examples can be found on this slide: New Hampshire, New York, Arizona, Missouri. Importantly, many state FOIA laws are built on a foundation of common law that was developed by state courts. And sometimes that common law can look radically different than the face of a FOIA statute. So it's not uncommon to read through state court decisions and find a FOIA rule that does not appear in the state statute. For example, a state court decision may have added an additional set of documents that are exempt from disclosure under the state FOIA rules. A classic example of this would be attorney-client privilege. To take one state, Massachusetts has a FOIA-type statute that does not clearly exempt attorney-client privileged information. In fact, the Supreme Judicial Court of Massachusetts noted that, quote, nowhere in the public records is the term attorney-client privilege found, unquote. Nonetheless, the Massachusetts courts have made clear that attorney-client privilege does not need to be disclosed to the public under the state FOIA law. So as that example suggests, a review of both state statutes and state court opinions may be helpful to understand the full scope of a state's FOIA law. Now that we've discussed FOIA in general, you may be asking when and why FOIA might be relevant to government contracting. There are a variety of scenarios where a government contractor may find itself asking about the scope of FOIA laws. In some cases, a government contractor may want to use FOIA as a sword, whether to obtain documents to support a position in a contractual dispute, or to obtain documents to understand an agency's award decision. In other cases, a government contractor may look to FOIA as a shield, particularly when a contractor's competitor makes a broad request for documents that potentially cover the contractor's documents. On the next few slides, we'll walk through 4 scenarios where a government contractor may want to consider the scope of FOIA laws. These scenarios are by no means exhaustive, but they provide an illustration of the potential importance of FOIA to government contracting. So let's begin with scenario 1. This is a potential dispute between a prime government contractor and the government. Suppose you're a prime contractor and experience an overrun on a fixed price contract. After some initial investigation, you believe that the government asked you to do work outside the scope of the original contract. Accordingly, this overrun may have actually been the result of a constructive change in the contract. However, while you had your suspicions about this constructive change, you may be missing some documents that complete the picture. There may be a variety of understandable reasons for lacking the documents. There may have been significant turnover, or documents may have been destroyed, or there may just not be emails. What do you do in these circumstances? Well, you may consider filing a FOIA request to get documents directly from the agency. Scenario 2 is somewhat similar, but involves a dispute between a subcontractor and a prime contractor. Suppose the subcontractor enters into arbitration over a contract dispute. Discovery is extremely limited. However, the subcontractor believes there may have been discussions between the government and the prime contractor, which were never conveyed to the subcontractor. How would the subcontractor access documents related to these conversations? A FOIA request may be one answer, though there may be other avenues to consider. The next scenario pertains specifically to state and local bid protests. I'll note that in federal bid protests, both the Government Accountability Office and the Court of Federal Claims require the production of some or all of the procurement record, albeit typically under a protective order. Accordingly, there's typically not as much need to file a federal FOIA request to seek documents to support a federal bid protest. That being said, many states and localities lack the same bid protest rules, and many states don't require the agency to produce any documents at all. This leaves the protester potentially looking to file a state FOIA request to obtain the documents it may want to support its bid protest. This can result in the need to simultaneously litigate both a state bid protest and a parallel state FOIA request. The final scenario contemplates a situation where the government contractor finds itself defending against disclosure rather than seeking disclosure of documents. Although FOIA is designed to allow for disclosure of documents, there are limits and exceptions that are designed to protect important interests. And the scenario here potentially implicates those interests. A government contractor does not want to see their trade secrets or other confidential information be generally disclosed to the public, and may not want that information, almost certainly does not want that information disclosed to its competitors. As will be discussed, the FOIA statutes provide a mechanism for potentially protecting those documents. Now that we've provided a general background on FOIA and discussed how FOIA can arise in government contracting, let us now discuss the type of documents that can be disclosed under FOIA. This conversation will focus on how federal FOIA defines records, though we will conclude with a brief discussion on state and local FOIA laws. When considering the type of documents that will be disclosed in response to a FOIA request, three questions are worth considering. Who holds the records? What records must be disclosed? And what records may not be disclosed? In other words, what exemptions may exist? So first, who holds the records? It's helpful to first understand who a FOIA request for records is aimed at. The federal FOIA statute only applies to agencies of the executive branch of the federal government. Accordingly, that excludes some government entities like the ones listed on this slide. To be sure, these entities may have their own disclosure rules. In particular, many state and local governments have their own FOIA laws, but these entities are not bound by the federal FOIA statute. Another important note about the definition of agency: the Supreme Court made clear that a government contractor cannot be the recipient of a FOIA request. Now, there's two important items to note about this limitation on government contractors. First, the government expressly made one exception for contractors that are, quote, subject to extensive control by the agency, unquote. This is meant to cover scenarios where there is extensive, detailed, virtually day-to-day supervision by the agency. Second, although a government contractor itself may not be subject to FOIA, an agency may need to produce a government contractor's records that are within the agency's possession as part of its own obligations under FOIA. That issue will be a focus of this presentation. So let's now turn to the records themselves. The federal FOIA provides a broad definition of records that covers any format, including an electronic format. This definition covers paper files in the agency's possession, as well as electronic files like emails and PDFs. It probably also covers metadata. This is an area that has not been conclusively resolved by all courts. However, in 2010, the Southern District of New York was at least understood to be the first federal court to conclude that metadata was required to be produced. And that was in an opinion called National Day Laborer Organizing Network versus U.S. Immigration and Customs Enforcement Agency. Consistent with that opinion, the DOJ released an open government plan in 2012, which spoke to the development of metadata standards for FOIA proactive disclosures. It's unclear whether all courts will require metadata in all circumstances, but metadata is at least a type of record to be aware of and consider. Although the definition of record is broad, there are a few items that the definition likely does not include. For one, tangible objects and physical evidence are probably not subject to disclosure. One case that looked at this issue was Friedman versus United States Secret Service. That's from the District of Columbia. Another area that is not covered by FOIA is answers to questions. So unlike civil discovery, where you can submit interrogatories and expect to get answers back from the counterparty, it's unlikely that you can submit such interrogatories under FOIA. At the very least, the agency may not be required to answer those. And finally, the agency does not need to create new records when responding to a FOIA request. According to the agency, does not need to create a compilation of information that did not previously exist. Another important limitation on disclosure to consider is agency control of the documents. An agency is only required to produce documents that are in the agency's control at the time the FOIA request is made. The Supreme Court has clarified that this means that the agency actually has the records in its possession, and not that it could obtain the records. This is significant for government contractors, as several circuits have interpreted the Supreme Court's guidance to mean that a document that is only in the contractor's possession does not necessarily count as an agency record. These circuits include the DC Circuit, the Ninth Circuit, and the 10th Circuit. The FOIA requester in these circumstances may argue that the agency could, in theory, ask the contractor for the document. However, that request potentially goes beyond what FOIA requires. There's one notable exception to this rule, which is found in the text of FOIA, the FOIA statute itself. If the government contractor has a contract for the specific purpose of managing government records, then the agency has to obtain the records from that contractor and produce them under FOIA. In addition to the limitation that the records must be in the agency's possession, there are also specific categories of records that are exempted from disclosure. These are typically known as the FOIA exemptions, and they can be found in subsection B of the federal FOIA statute. It should be noted at the outset that these exemptions do not necessarily mean that a document will be excluded from production altogether. Rather, the FOIA rules instruct that the agency must still produce reasonably segregable portions of the record that are not exempt from disclosure. What that means is that, where possible, the agency would redact exempted information from documents and then produce the redacted copies to the parties. The possibility of redactions is something to consider when a government contractor has submitted a FOIA request and is seeking information. A redacted document could be a compromise or alternative to requesting an entire document. Alternatively, if a government contractor is in a position where it learns that the government's planning to produce documents related to that contractor's work, then it could consider whether those documents could be redacted rather than being produced in full. This slide shows the 9 exemptions that can be found in the federal FOIA statute, so at 5 USC 552B. We're going to focus this presentation on 2 exemptions that are particularly potentially applicable to government contractors. These are the ones that are bolded and underlined on the slide, and these are exemptions 3 and 4. By focusing on these 2 exemptions, you'll get an illustration of the potential complexity that can be found within each category of exemption. Whenever one encounters a question about FOIA disclosure, there is good reason to look at all of these exemptions and consider their applicability. Any of these exemptions could apply to a question of government contracting, depending on the particulars of a situation. And it will often be the case that where one FOIA exemption applies, 1 or 2 other FOIA exemptions also could arguably apply. So to prepare the best argument for or against disclosure, one may consider the applicability of each exemption. For our purposes today, we'll begin by focusing on Exemption 3. Exemption 3, as this quote from the federal FOIA statute shows, exempts anything that another non-FOIA statute specifically exempts. So to determine whether this provision applies, one would need to review other non-FOIA statutes that potentially relate to their situation and see whether those statutes involve provisions that relate to FOIA or public disclosure. For example, if a FOIA-related dispute involves an HHS contract, one would want to look at the statutes related to HHS, as well as any statutes cited in the contract itself. Then, once one has identified any statutory provisions that discuss the disclosure of documents, one would then need to consider whether it fits the specific criteria detailed on this slide. We're going to briefly discuss two types of statutory provisions that are potentially particularly applicable to government contractors in connection with FOIA Exemption 3. This first slide discusses those exemptions found in FAR 24.202. FAR 24.202 provides a list of exemptions which can be found in other statutes and are specific to government contracting. Perhaps most significantly, this FAR provision states that a proposal submitted to the government is exempt from disclosure. Now, there's an important exception to this rule for a winning proposal when that proposal becomes incorporated into the final contract. But otherwise, an offeror can anticipate that a proposal submitted in connection with a federal government procurement will not be disclosed. I'll note here that this prohibition on disclosing bid proposals is specific to federal FOIA law. This prohibition may not necessarily exist under state FOIA law, and state governments may in fact produce proposals in response to a state FOIA request, depending on the applicable law. The second type of statutory provision that merits particular consideration relates to the False Claims Act. As you may be aware, the False Claims Act prohibits the submission of false claims or statements to the federal government. One of the government's mechanisms for obtaining information about a potential False Claims Act violation is a civil investigative demand, or CID. A CID is similar to a subpoena, and it requires the recipient to provide documents and information to the government in connection with an investigation. But importantly, the documents and information provided to the government are exempt from disclosure under the statute. In light of this rule, when responding to a CID, some contractors apply protective labels reminding the government of the fact that the productions are exempt from disclosure under FOIA. In addition to FOIA Exemption 3, as we've been discussing on the last few slides, FOIA Exemption 4 is of particular interest to government contractors. This exemption protects trade secrets and commercial or financial information obtained from a person and privileged or confidential. So when contracting with the government, a contractor may provide the government with certain information that the contractor considers to be trade secrets or confidential. The question then becomes whether that information falls under this exemption and is protected from disclosure. Helpfully, the United States Supreme Court has recently provided some clarification on the meaning of this provision in its decision in Food Marketing Institute versus Argus Leader Media, sometimes referred to as food marketing and other times referred to as Argus Leader. We'll be discussing that opinion over the next few slides. It's helpful to begin with some context for the food marketing decision. Before food marketing, many courts followed the approach of the DC Circuit in National Parks and Conservation Association versus Morton. The National Parks decision required a showing of harm before a document would be treated as confidential. That harm could take one of two forms shown on this slide, but some type of harm had to be shown. However, the Supreme Court then rejected that harm requirement in the food marketing decision. Food marketing involved a request for information related to the Supplemental Nutrition Assistance Program, or SNAP. The requester who submitted a FOIA request asked for the specific dollar amount of SNAP benefits each retailer redeemed. But the retailers explained in opposition to the FOIA request that SNAP redemption data was kept confidential within the industry, and that this information should be kept from disclosure under FOIA Exemption 4. The Supreme Court, in an opinion by Justice Gorsuch, rejected the harm requirement found in national parks. The Supreme Court relied heavily on the definition of confidential and found that an element of harm was notably lacking from dictionary definitions, early case law, or any other usual source that might shed light on the statute's ordinary meaning. Given that the harm requirement was rejected, the Supreme Court had to determine what the correct definition of confidential may be. In doing so, the Supreme Court identified two possible conditions that are inherent in the idea of confidentiality. These are the two numbered points on this slide. First, whenever information is customarily kept private, or at least closely held, by the person imparting it, then it may be confidential. This generally means that the contractor themselves tried to keep the information secret. Second, when the party receiving the information provides some assurance that it will remain secret, that may also be part of the definition of confidentiality. This generally means that the government promised in some way to keep the information secret. After laying out those two conditions, the Supreme Court then openly asked within the decision whether both conditions had to be met. The court then declined to answer that question. The court noted that the first condition has to be met, i.e., the idea that the information is customarily kept private, but it did not opine on whether the second condition had to be met. Rather, it simply noted that when it came to the SNAP program at issue in food marketing, the government had long promised to keep the documents protected, and so both conditions were satisfied on the facts presented before the court in that case. As you can see, the Supreme Court left open some questions about the exact scope and meaning of Exemption 4. Accordingly, following Argus Leader, the Department of Justice published guidance for agencies on how to follow Exemption 4. This guidance is not binding on the courts, and it may not represent the final say on the meaning of Exemption 4, but it does provide one perspective on how agencies are potentially viewing the meaning of confidentiality. Regarding the first condition laid out in Argus Leader, the submitter's treatment of information, DOJ detailed the types of evidence that might be considered before producing or withholding a document. This includes the agency's own knowledge about the industry, the submitter's practices, and the records themselves. So if a contractor is seeking to ensure that information is protected, they may consider how they're conveying that intention to the government. Regarding the second condition laid out in Argus Leader, the assurance of confidentiality by the government, DOJ acknowledged that this may not be an actual requirement. However, DOJ recommended that agencies should at least consider whether any assurance was given. Thus, if a contractor is seeking to have this exception apply, they may want to look for past assurances they've received from the government. To emphasize, this guidance is exactly that, guidance. It's not yet clear whether all courts will follow the exact path laid out in this DOJ guidance. We've spent the last few minutes discussing exemptions 3 and 4. 3 is exempt by other statutes. 4 is confidential business information or trade secrets. However, it's important to remember that these are just two pieces of the puzzle and that there are several other exemptions in the federal FOIA statute. A government contractor may want to consider all of the exemptions, whether it's the party seeking the documents or the party trying to prevent the documents from disclosure. Now that we've discussed the types of records that can be disclosed under the federal FOIA statute, we also want to consider the types of records that can be disclosed under state or local FOIA laws. Given the wide variety of laws and jurisdictions, it's impossible to speak about every aspect of state and local FOIA laws in a timely manner, but a few big picture ideas are worth considering whenever a question of state FOIA law arises. First, state FOIA exemptions can be quite different from federal FOIA exemptions. Just because an exemption exists in federal law does not necessarily mean it will exist in state law. A good example is government contractors' proposals. The federal law prohibits the disclosure of non-winning proposals, but many states do allow for disclosure of proposals. Given that, contractors could consider submitting a redacted version of the proposal to state governments at the time they're submitting a bid. And indeed, many state government solicitations expressly request such a redacted document along with justifications for the redactions. Second, some state FOIA laws include, in addition to a list of specific exemptions, a catch-all provision that generally exempts documents where the private harm outweighs the public interest, so a balancing test. This catch-all balancing provision does not exist in federal law, but it may well be found in state and local law, so it's another exception to consider. Third, and finally, exemptions may not be found in the text of a state statute at all. As previously discussed, many state FOIA laws rest on a foundation of common law and have been reinterpreted through the lens of common law. Accordingly, the way a state court interprets its state's FOIA statute may look quite different than what a plain reading of that FOIA statute suggests. A good example of this was discussed earlier in the presentation. The state of Massachusetts will not disclose attorney-client privileged information, even though there is not a provision in the state statute exempting attorney-client privileged information. So a review of judicial opinions may be something to consider when reviewing state FOIA laws. Now that we've discussed the types of records that can be obtained under FOIA, let us now turn to the process one can generally expect to see after a federal FOIA request is submitted. As an initial note, there can be some variety between the exact way that different federal agencies approach FOIA. We'll be discussing the general approach, which is by and large what federal agencies follow, but it is good to check on the rules for the particular agency that is at issue. And as noted on this slide, each agency should have its rules published online. Here is a general timeline for a FOIA request, which we will detail over the next few slides. First, the FOIA request is submitted. Then, the agency will collect the documents, which can include conferring with the government contractor that initially provided the documents to the agency. Then, the agency responds to the FOIA request. And finally, there can be a dispute over the agency's approach to the FOIA production. So submission, notification to the person or party that originated the documents, agency response, and then potentially dispute and litigation. We begin with the submission of the FOIA request itself. A FOIA request can be submitted directly to the federal agency, following the guidelines laid out by that specific agency. In addition to submitting a request directly to an agency, a requester may also be able to submit the request on FOIA.gov. As a result of a recent amendment to FOIA, Section M of the FOIA statute now instructs the Office of Management and Budget, or OMB, to create a consolidated online request portal. That portal, FOIA.gov, is still being improved and refined, but it may be a helpful platform for submitting a request and can be found online. Regarding the actual request itself, there is no set formula. However, the document will typically capture at least 3 items listed in the bullets on this slide. First, the request will describe the documents requested. Under 5 U.S.C. 552 A3A, the FOIA request must reasonably describe the record sought. This means that a requester should consider providing as many details as possible about the documents and specify the format for the requested records. Second, the request should be in accordance with published rules and procedures set out by the agency. That requirement can also be found in the FOIA statute. Third, the request typically identifies whether the requester is willing to pay fees and how much it is willing to pay. Notably, the federal FOIA statute limits fees to reasonable standard charges for document search, duplication, and review when records are requested for commercial use. Once a FOIA request is received, the agency begins to identify records and prepare its production. At this stage, the agency may realize that it has documents from a government contractor and that it should give the government contractor notice that it is going to produce those documents. This notice is known as a pre-disclosure notification. Agencies have long provided pre-disclosure notifications and are required to have established procedures for these notifications pursuant to Executive Order 12600. That executive order explains that agencies should notify third parties when documents containing confidential information are to be produced. Although the executive order and related DOJ guidance only speak to the notion of confidential information, there's nothing preventing a government contractor from raising other FOIA exemptions once they receive a pre-disclosure notification. When an agency provides a pre-disclosure notification, the agency must give the third party a reasonable time to respond before the agency makes the FOIA disclosure. And then, in the event that the third party objects to the disclosure, the agency must provide its final decision to the third party in a, quote, reasonable number of days, unquote, before it makes the FOIA disclosure. That way, the third party can, in theory, move to prevent the FOIA disclosure if they so choose. If the agency and the third party cannot come to an agreement on whether an exemption applies, this can lead to reverse FOIA litigation. In reverse FOIA litigation, the third party seeks to prevent information from being produced by an agency. This type of litigation is brought not under the FOIA statute, but instead under the Administrative Procedure Act. Essentially, the company seeking to protect the information is arguing that an agency's plan to release information violates the APA because it's either not in accordance with law or it's arbitrary and capricious. If the company is successful in its reverse FOIA litigation, the court will enjoin the agency from producing the identified information. Next, the agency will respond to the FOIA request. As an initial matter, and often before the pre-disclosure notification, the agency will provide the requester with a notice that it acknowledges the FOIA request. This acknowledgement typically comes within a week or two of the initial FOIA request, and it may ask the requester for clarification on the types of documents the requester is looking for. Following that initial acknowledgement, the agency will then produce the records themselves. The federal FOIA statute requires that documents be produced within 20 working days. But as a practical matter, the average response time is typically much longer. The FOIA statute allows for this, noting that the agency can rely on the fact that exceptional circumstances exist and that the agency is exercising due diligence in responding to the request. Nonetheless, courts have indicated that documents are supposed to be produced in a matter of days and weeks, and not necessarily months or years. Notably, a failure to timely produce documents can serve as a basis to sue the agency. If the agency is taking a particularly long time to respond, a contractor could file a lawsuit and request for a timely production of FOIA documents, which can lead to further litigation. As the discussion on the previous slide suggests, there are many disputes that can arise over the adequacy of a FOIA production. The agency may not be producing the documents, or it may have produced too few documents. Or the agency may have produced all the requested documents, but they're heavily redacted. Any one of these scenarios could lead to a dispute over the FOIA request. Prior to commencing litigation in federal court, a requester has a few potential avenues available to it. First, the requester can simply correspond with the agency's FOIA officer to see if the matter can be resolved through a reminder or a clarification. Second, the requester can file an administrative appeal within the agency. Each agency has its own procedures, but the deadline for submission is typically short, usually within 30 to 60 days of the agency's FOIA production. And notably, this appeal is typically required before a requester pursues litigation in federal court, or else the FOIA challenge in federal court may not be considered to have been exhausted. Third, as an alternative to appeal, the requester can consider pursuing mediation with the Office of Government Information Services, or OGIS. Under the FOIA statute, this office is required to offer such dispute resolution services as a, quote, non-exclusive alternative to litigation, unquote. However, the authority of OGIS is fairly limited. The office cannot compel an agency to release records or to reverse its FOIA decisions. But the office can meet with the parties and issue recommendations on the best path forward. Information about the office can be found on the website of the National Archives. If the requester ultimately decides that the best avenue is federal court litigation, that is also an option. Litigation can commence at one of three times. First, when the agency denies the administrative appeal. Second, when the agency fails to timely respond to an administrative appeal. Or third, when an agency fails to produce documents within the time limits laid out in FOIA. A requester has three options for where to file such a case. Those are listed on the slide here: the district court for the District of Columbia, the district court where the requester resides, or the district court where the records are located. We will not discuss every facet of FOIA litigation in federal court, but this slide highlights three key aspects of FOIA litigation. First, in FOIA litigation, where the agency has missed the deadline to produce documents, the agency may file an Open America motion. In an Open America motion, the agency requests that the FOIA litigation be stayed or paused so that the agency can have extra time to complete its FOIA production. The motion gets its name from the D.C. Circuit's decision in Open America versus Watergate Special Prosecution Force, where the FBI was working to respond to a large number of requests related to the Watergate scandal and investigation, and it asked for more time to respond to a particular request for 38,000 pages of records. In that case, the D.C. Circuit explained that an agency can be given more time to produce the documents if there are exceptional circumstances and the agency is proceeding with due diligence. There can and will be disputes over whether those circumstances are existent in each individual case, but an Open America motion may put a pause in the litigation and allow the agency more time to produce documents. Second, once FOIA litigation has begun, the agency will be expected to prepare and produce a Vaughan Index. This is named after the case Vaughan versus Rosen. A Vaughan Index provides a description of each document being withheld alongside a justification of the agency's decision to withhold the document. This allows the courts and other parties to understand the agency's position without actually requiring the documents to be produced. These Vaughan indices can be thought of as somewhat similar to privilege logs, although not exactly the same. Third, and finally, if a FOIA requester is successful in their litigation, they may be able to obtain reasonable attorney's fees and other litigation costs from the agencies. This provides or potentially provides an incentive for agencies to err on the side of disclosure. Throughout this presentation, we've considered the applicability of FOIA laws to government contracting. In particular, we've looked at the type of records that can be requested and the process for requesting documents. We will end today's presentation with a few key takeaways to consider, as well as some questions for the group. First, FOIA laws can be a useful tool for government contractors looking to obtain additional information about agency action. If you are considering litigation over the performance of a contractor or you're a bid protester challenging an award made by a state or local agency, there may be an interest in obtaining additional documents, and FOIA, whether federal, state, or local, may be able to help. Second, FOIA laws can also protect government contractors' information from disclosure in certain circumstances. When a requester seeks information related to a government contract, there may be good reason why production would be inappropriate. The request may seek confidential information or trade secrets. The request may seek documents provided in the course of responding to a civil investigative demand pursuant to the False Claims Act. Government contractors who want to protect their information can consider whether an exemption applies and advocate for that exemption to apply. Third, state FOIA laws can differ from federal FOIA laws. Just because an exemption exists under federal law does not necessarily mean it'll exist under state law. Moreover, it is possible that more exemptions might exist in the state law. Government contractors may want to consider these differences whenever a question of state or local law arises. Fourth, and finally, it's important to consider both FOIA statutes and judicial opinions when attempting to answer a question about the applicability of FOIA. As the Supreme Court's opinion in Argus Leader shows, a court's interpretation of a FOIA statute may provide important details that are not necessarily apparent when reading the FOIA provision on its own. And this review can be even more significant in state court, where the common law reflected in state judicial opinions can look wildly different than what appears in the state FOIA statute. So we're now going to move to a few knowledge checks, some true or false questions, and we'll open up the polls to allow people to participate here. And so I will now go to question 1. So true or false? Documents from the state of Arizona are discoverable through the Freedom of Information Act.
I've got that poll up. I'll give you guys a few moments. I'll give you guys a few more seconds. Alright, I'm going to go ahead and share those results. Looks like we've got 56% choosing true and 44% choosing false.
And it is somewhat of a tricky question, but the answer is actually false. So documents from a state government can't be discovered through the federal FOIA, but they may be discovered through a state equivalent. Here, the state of Arizona does have a public disclosure law. It's called the Public Records Law. And so you could discover documents through that process, but you wouldn't be able to get documents through the Federal Freedom of Information Act. All right, we'll go to the next question here. True or false? A proposal that is incorporated into a contract is discoverable under FOIA.
Again, I'll give you guys a few moments. Alright, I'm going to go ahead and share those results. Looks like we've got 79% choosing true and 21% choosing false.
And true is the right answer there. So under the FAR provision, when a proposal is incorporated into a contract, it is then discoverable. The general rule under the FAR provision is that a proposal is not discoverable, but once it's incorporated into a winning contract, then it is discoverable. So true was the right answer there. And then our final true or false question. For information to qualify as confidential, a party must show that the public release of the information will cause harm to the other party.
Alright, I'm going to go ahead and share those results. Looks like we've got 57% choosing true and 43% choosing false.
And the answer to that one is false. So under the DC Circuit's decision in national parks, there used to be a harm standard, but the Supreme Court in the Argus Leader decision rejected that harm standard. So as a result of that Supreme Court decision, you are not required to show harm in order to qualify as confidential and thus potentially exempt under FOIA.
Thanks so much, Andrew. All
Absolutely.
right.
And we'll now turn if anyone has any questions. Again, thank you so much for attending today's presentation. This has been Government Contracts 101, Freedom of Information Act. Again, my name is Andrew Guy, and happy to answer any questions anyone may have.
Thanks, Andrew. I'll give everyone a few moments to send any questions. If there are no questions, we would love to know how we did today. All feedback is greatly appreciated. Those of you seeking credit, you'll log into your certificate in courses. The course will pop up by the end of today. Make sure you guys fill out, or actually you won't need to fill out a password survey, but if you are seeking a certificate, you'll go through your account on our website, and if you have any questions about that, feel free to let me know. I'll be more than happy to guide you through. If there are no questions, I wish everyone a wonderful afternoon. Thank you all so very much for joining. Thank you, Andrew, for a wonderful session. Make sure you guys check out PCI's website for our upcoming programs. We do have our next GovCon 101 on September 23rd, covering Part 52, and we hope to see you all again. With that, I wish everyone a wonderful afternoon. Thanks, Andrew.
Yep, thank you. Everyone have a great day.